Good morning, everyone, and welcome to Surviving the HR War. I'm Vinny Civitello, Communications Manager for the New Jersey Business and Industry Association. With us today is our very own Vice President of Member Value, Stefanie Riehl. A few housekeeping matters before we get started. Today's webinar is being recorded and will be emailed to you automatically along with the PowerPoint for today's presentation, so be on the lookout for those. I'd also like to draw your attention to the questions tab. Stefanie would be happy to take all of your questions, so don't hesitate to write them in as they come to you, and I can't stress that enough. Write them in as they come to you, or you may forget what you wanted to know by the time we hit the Q&A. Today's seminar is eligible for one HRCI SHRM credit hour. For those seeking the credit, please make sure to write down the codes that have been embedded into the presentation today. Please send an email to member411@njbia.org after today's webinar concludes with the codes. Please note that if you are listening to an archived version of this program, you will not be eligible to receive any credits. So now let's get things started. Stefanie?
Good morning, everybody. Welcome to Surviving the HR War. So before we begin, I have to show this slide. I am not an attorney, but I am friends with some attorneys, and they tell me I have to tell you that I'm not an attorney. So there you go. With that out of the way, as Vin mentioned, we are going to be awarding HRCI or SHRM credits for this program. If you want to receive them, you should contact my colleague Kim, and also you're going to have to take note of some codes that we're going to be showing randomly throughout the presentation. So let's dive in. Well, many of you are our members, so you can read more about our mission, vision, and values at the Business and Industry Association, but I really want to stress that what sets us apart is the diverse offerings that we're able to give our members. We are the country's largest employer-based trade association, so that means that we can do a lot of the same things that like a Chamber of Commerce could do, but more. And what do I mean by that when I talk about the more? Well, one of the things that we have that you should check out if you haven't already is our Health Benefit Solutions program. This is a new program that we just launched this year, and many of our members have found savings. So if you want to check it out, you can get a quick quote on our website. The other thing that sets us apart from other trade associations is our Member Action Center. And that's the center that generated all of the content for today's webinar. So a little bit about me. I left a 12-year career as a lobbyist to run our Member Action Center because I wanted to give my parents a heart attack. But besides that, because I felt very strongly that businesses needed some place to go where they could get some help with their day-to-day activities and staying out of hot water. So this opportunity was presented to me, and it's been fantastic working with all of our members. So let's talk about what the Member Action Center really encompasses. Well, first, there's our 24/7 call center and email. So that number is 1-800-499-4419, extension 3. Again, 1-800-499-4419, extension 3. And also member411@njbia.org. So you can reach us there with any business question. So that's part of our first bucket. We also have white papers that is part of our first bucket as well. We have over 60 white papers on everything you could need, to shopping for health insurance, to complying with the new paid sick leave law that will be enacted later today. More about that in a little bit. We also have 3 legal hotlines for our members. So we have a business disputes hotline, a business operations hotline, and an HR hotline. Altogether, as a member, you're going to get 90 minutes of free legal consultation a month. That's all included in the cost of your yearly dues. We also have webinars like today's, seminars, and in addition, we're really ramping up our HR affinity programs. So for instance, we do have an HR affinity program that provides disability insurance. So you know how you have to get that disability insurance through the state in the event that one of your employees has an accident or injury outside of work. Well, in this case, you may save money by going with a private provider as opposed to the state plan. So you can find out more about that program on our website as well. We also hope in the next year or so to provide you with a payroll processing affinity program and a 401k program as well. Last but not least, the last bucket is our NJBT articles. That's our daily newsletter that goes out that has HR articles in it. And again, our 60 or so fast facts that you can get on our website. So our call center gets around 1,000 calls from employers just like you every year. One of the reasons why I think we get so many calls is because of this. This is what I Googled this is what I got when I Googled the last time ways to sue your employer. So 19.8 million ways to sue your employer comes up in less than a second. So the deck is stacked against you. You have not only your employees to worry about, but you also have people like this gentleman. Now, this is a true call that came in. This gentleman calls us and says, I don't want any of those HR laws I've been hearing so much about to apply to me. So I've just decided to stay under 50 to not get sued. Yeah, that was filed in the let's pretend that never happened category. But more than that, I'm sure you know this man or you know someone like him, right? You're just trying to go about your business and you're trying to monitor your employees. And then you have somebody like this who's saying, just get it done. I don't care about the HR laws. And so your day may look like this, right? The tip of the iceberg is the work product your boss or your client sees, whereas the rest of the day is everything that you have prevented. So hopefully today will make it a little bit easier for you to deal with those daily issues you have and stay out of hot water. Now, I'll tell you, I looked at the registration list ahead of time, and I see that there's a wealth of experience on the line. And so hopefully you walk away with a snippet of something you haven't learned before. Maybe you get a couple of chuckles, and you enjoy my references to pop culture that I'm going to put throughout this event today. So let's dive into our first topic, which is employee leave problems. I think that there is maybe no topic that makes HR professionals and business owners quite as unsettled as employee leave. So let's talk about a situation that came in from one of our large employers. So this employer called us. They are part of a large employer, over 50 employees. They have corporate counsel, but they wanted to call us because they just wanted a second opinion before they went to corporate counsel. And that happens from time to time. That's part of why the Member Action Center is there. So this person calls us and says, one of my employees is going to be fostering a step grandchild for at least a year. So she's going to be the step grandmom. She wants to take some sort of leave to help with the baby. Is that covered as a protected leave? Now, I'm going to assume here that everybody has somewhat of a basic knowledge of the leave laws. So we're talking about protected leave, which would be the Federal Family and Medical Leave Act. And then we're also talking about the New Jersey Family Leave Act as well. So if you don't have a basic knowledge of the leave laws, you're obviously welcome to call us anytime. We'll give you kind of a crash course. We also have a seminar coming up in September. Well, let's talk about why this is relevant right now. I think what you're going to see is as older workers stay in the workforce longer and longer, that you're going to have grandparent caregivers. So 60% of grandparent caregivers are still in the workforce. 4% of all US children are being raised in grandfamilies. And for every child being raised in the foster system, nearly 25 are being raised by grandparents or other relatives outside the system. So what we saw, I think, from all of the problems with the economy in 2007, 2008, is that people are really staying in the workforce longer because they're trying to beef up their 401ks and have the money that they need to retire. So if you haven't seen this yet, you may see it. So let's get back to the situation at hand. Are grand step babies covered? Are step grandmothers covered? Well, if you look at the definition of FMLA, you'll see that the definition for family member is really pretty limited. So spouse, children, son or daughter doesn't include parent-in-law. If we move over to New Jersey Family Leave Act, you'll see that it covers a lot more, and it does have some of the step relationships in there, like a step parent, a parent-in-law, and relationships of that sort. So if you weren't already kind of trending and figuring out what we were going to suggest that this employer do, this should probably make the decision a little bit easier for you. Employer writes back to us and says, the employee will be listed as a resource parent on all of the paperwork, applications, everything for this child. So does this change things? So again, while there's no language in the law or regulations of either law to directly address this situation, we do have some guidance now, especially now that we know that this person is going to be designated as caring for that baby. So under the FMLA, a person can stand in loco parentis to a child and form a parent-child relationship. They do this by providing emotional or financial support. So it seems that with the situation we were presented, those two things are happening. Also, under NJFLA, parents are in-laws, step-parents, foster parents, adoptive parents, or others having a parent-child relationship. So what we suggested this employer may want to consider doing is running NJFLA and FMLA concurrently. That's because the employee could qualify for leave under both. Document, 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 right? That's one of the things that we always say at all of our programs, document, document, document. And essentially, the employer may want to consider granting the leave in this case because it would seem that the facts support that there is a relationship that could be covered under one or both of the laws. All right, so let's talk about another leave issue that we get quite a bit. This is employees going out for sick days and us maybe questioning if the need for those sick days is legitimate. So we had an employer stand up in one of our seminars and ask what to do about this situation. The situation was that several of their employees are all requesting leave from a doctor that's located internationally to get their gallbladders out. Now they're coming back, maybe losing a gallbladder, but gaining a cup size. And this has been 4 or 5 employees at this particular company. Now this is a very extreme example, right? And I think most employees are really good people that just want to do right by their employers and that want to do an honest job for an honest day's pay. But let's talk about this a little bit more. So again, we get this question a lot, and you can see that there's actually a market for fake doctor's notes. Yes, there is a website, bestfakedoctorsnotes.net. If you have an hour of your life that you're not looking to get back, I would recommend playing on it because it is really, really enlightening. So in particular, the dentist notes are among the ones that are the least challenged. And this site is so advanced that you can even set up a number with your area code that has an automated voicemail system. So when the employer goes to call to make sure that this is a legitimate doctor, they can hear a preloaded MP3 that sounds a lot like a doctor's office or a hospital. So what do we do? Well, we know that this happens. We know that especially when the Super Bowl comes, a lot of employees call out sick on Super Bowl Monday. And 80% admit to feeling guilty about it. Not so guilty that they're not going to do it, but they are guilty about it as they sleep the day away. And unexcused absences can cost organizations 8.7% of payroll. So what do you do? Well, I think the first thing that you have to consider is whether this absence is non-FMLA or FMLA. So it could be a non-FMLA qualifying absence because maybe the employer that we're talking about has less than 50 employees, so it's not covered by FMLA. Or it could be because maybe the absences are intermittent. So maybe it's the Monday after a holiday that the employee is constantly absent. So in that case, it wouldn't be FMLA. So let's go non-FMLA first. One of the things that you can do is ask that the note be written on a prescription pad. That would solve the problem that you're having with the employee that's using that wonderful website, Best Fake Doctor's Notes. You can also contact the doctor for verification that the note was written by them on the date claimed. Now you have to be really careful. That's all going to be need to know information, not want to know. Because remember, the more that you find out, the more that you could have yourself become liable for a HIPAA claim. So it's really need to know information. And so let's say it is an FMLA reason for the leave. Now, you know that you can request medical documentation and the employee has 15 days to return that medical documentation. Even if you don't think that there is any kind of fraudulent activity here, you should still document all your leaves. Remember, we say document, document, document. You're going to be tired of hearing of that after this webinar is over. The other thing that you can do is, if you don't think the part that's filled out is legitimate, you can use another person to verify. So we always recommend somebody that's not a supervisor, that is impartial, and that will keep all information confidential. So let's say that you're still concerned. Well, you can pay for a second or third certification and choose the provider, but your third certification is binding. And so those are just a couple of the things that you can do with regard to some illegitimate uses of leave. The other thing I will say is that a lot of employers have a very strict policy concerning leave. Now, up until today, arguably, you could have such a strict policy. But now here's where the but comes in. Probably before you leave your office today, which is May 2nd, there is going to be new legislation that gets signed by the governor. That's paid sick leave. That's on the governor's desk right now. He's expected to sign that today. What it's going to say is that most businesses have to provide up to 40 hours of paid sick leave. Now, you can provide more, but you have to provide at least 40 hours of paid sick leave. And you may be sitting here saying, well, I am a very generous employer, and so I provide more than that, so I don't need to worry about that. Not so fast, because there is language in the laws that would maybe affect your call-out policies. For instance, the part of the law that I have circled says that you can only request doctor's notes for absences of 3 or more consecutive days. So if you do otherwise, that could result in liability for you. And the other point that I want to make is that this law specifically says that you cannot require employees to find their replacements. So that often becomes a concern with shift work, but you cannot require employees to find their replacements. So it's a good idea to go over your policies right now if you are providing more than 40 hours of sick time, to just make sure that you're in compliance with the law. And we'll be issuing a white paper later. We also have a seminar coming up on June 5th that's going to do a deep dive. Oh, there's our verification code to make sure you're still with us, 8943. Go ahead and take that down. So let's move on to the next topic. I've decided to add extensive experience dealing with stupid people to my resume. That has got to be a marketable skill. Yes, indeed it does. So let's talk about some difficult employees and difficult situations that we've gotten through our Member Action Center. So you know when you come into work and you can just tell that the phone is ringing with such urgency that that person on the other line really needs to get a hold of you right then? Well, this is what I came into one Monday morning at 8 o'clock. And so this employer calls us and he says, I came into work, I found a letter signed by several of my employees. They're threatening to strike if I don't address an affair one of my managers is having with his subordinate. The employees are saying the manager is now favoring the employee at the expense of others. Help, what do I do? So the first thing I said is, how do you know this to be true? Right? Because I want to make sure that the employer is doing their due diligence, and because I'm also a bit nosy here. So how do you know this to be true? Well, it turns out that the wife of the supervisor called and asked that the employee who was having an affair with her husband be taken to task. So that was pretty reliable information that this was in fact going on. Let's talk about the stats on workplace love a little bit. I think these days it's relatively rare that you have a manager and a subordinate that are involved with each other. It's probably going to be even rarer because we've seen with the hashtag #MeToo movement, but it does still happen. And so let's talk about some of the implications where it does happen. Well, of course, there's the effect on employee morale. So we saw that these employees that were not part of the affair but felt that they weren't getting favorable treatment as a result of it were threatening to strike. So obviously, that's something that you don't want to have going on, where you have a morale issue from some kind of extracurricular activity that your employees are doing. Of course, there's allegations of favoritism, and then more serious things like a possible sexual harassment claim and more serious claims leading to liability for the company. So for instance, suppose the subordinate comes back and says, you know what, I never consented to this, and this was outright assault. In addition, when this employer called us, he was very concerned about his workers that were threatening to strike and wondered if he could discipline his workers for threatening to strike. Probably not. Now, there's a couple reasons for that. The first is under federal law, even if you're not a unionized workforce, your employees may still be protected when talking about things like threatening to strike, their working conditions, their wages, things like that. And if that wasn't enough, there is another law that was just signed that takes effect July 1st, which is going to protect employees who discuss things like salaries, job titles, and occupational categories. That's going to also require you to justify some of your merit-based pay systems. And again, we have compliance documents on that. We also have a seminar coming up, so if anybody needs that, email us at member411@njbia.org, and we will get that to you. So what should this poor employer do? Well, we talked about it, and as it turned out, the employer had 2 plants on the same site. So we talked about, could the supervisor be transferred to a different building? The employer said, yeah, I think that could happen. Now, why did we say the supervisor as opposed to the employee? Well, you wouldn't want to retaliate against the employee, so it's easier to transfer the supervisor in this case, because you wouldn't want the employee to say, well, I'm being transferred because I had some sort of a claim against the company. Obviously, you want a handbook to prevent this in the future. Now, I know all 100 of you that are on here have a handbook, and I'm sure it's up to date, and you just looked at everything yesterday in advance of the new paid sick leave law. But if you haven't, go ahead and do that. And then in this case, the employer would want to contact an attorney, probably to mitigate a future harassment claim, discuss company liability, and address the striking workers. Okay, so the next case study we are going to move on to and talking about difficult employees and situations is this one, which we get a lot. I have an employee who's constantly stirring the pot with other workers. The latest demand is that she and other employees be given access to their personnel files. Do I need to comply? So this is really 2 problems, right? We have the gossiper as one problem, and then we have the personnel file as the other. So what do we do? Let's talk about the pot stirrers first. There's an episode of The Simpsons where Homer finds himself in possession of damaging information on his neighbor Flanders, which he says would amuse the whole town. In contemplating what he's going to do about it, he says, if I gossip about it, it'll make me feel important without being drunk. That'll be weird. So what can we learn from Homer Simpson? Well, we can learn that a lot of employees want to stir the pot, or whether they do it consciously or subconsciously, because they want to feel that need to belong. And so if you look at these statistics, 62% of employees opt to confront toxic coworkers, but 78% claim their organizations are extremely to somewhat tolerant of those with negative attitudes. And 30% of employees argue with coworkers once a month. So now that we know about the pot stirrers, let's talk about the personnel files. Well, there's no federal law that says that you have to give your employees access to their personnel files, and the laws vary from state to state. So Massachusetts, for instance, has a very broad law that says you have to give current employees and former employees access to their personnel files. How do I know that? Well, an employer just called us yesterday with that question. They have an employee who is being paid through a New Jersey office but is located in Massachusetts, was terminated, and now the employee wants access to their personnel files. So you really have to be careful if you are a multi-state employer to know what all of these laws say. So in some cases, these laws are going to say that it's just limited examples of what is provided. Like for instance, in Missouri, is just information related to workers' comp claims. So your knee-jerk reaction may be to say no, but a couple of things you can consider. One of the things is that New Jersey has considered legislation in the past. We still don't have a law, but we may at some point, somewhere down the line. And if you speak with attorneys about this, a lot of them will say, no, absolutely not. Positively, under no circumstances do you provide access to personnel files. Others will say, nah, maybe you do. So I'm going to go with the maybe you do, because if I didn't, I wouldn't have a slide to show you right now. So here's what I'm going to say that you might want to consider. You might want to consider adopting some sort of a policy. So maybe you have a green, yellow, red. Green unrestricted, yellow need to know, and red off limits. What do I mean? What's unrestricted? Well, green might be someone's employment application, maybe performance appraisals, maybe commendations and discipline. This is all stuff that they should have already had before in their records. Yellow might be their employment references, their I-9s, maybe tax forms, attendance records, investigation files. Again, this is need to know. Red is off limits. Very often what would be off limits in a red policy would be medical records, which we all know need to be kept under separate lock and key. Let's go back to the difficult employee situation, right? Because we all have those. So you want to tie negative employee behaviors to goals and objectives. Is there something that this person is doing that is preventing them from accomplishing their goals, or maybe those around them accomplishing their goals? Obviously, you want to document instances where behaviors have compromised goals. I also like the idea of creating an employee complaint form. So there are organizations that we have heard from where their employees are complaining about everything, even that the free bagels are stale and they can't wear jeans on a Friday. So when these organizations have instituted a complaint form, they've gotten two things. They've gotten documentation on every complaint, and then they've also dissuaded people that just kind of wanted to blow their lids a little bit, but didn't really want to go through the work of actually filling out their concerns. The other thing that you can do if you have an employee assistance program is refer the person there. But I also like to take a step back and say, what can you do to prevent gossip in the first place, right? We know it's so pervasive that even Homer Simpson has it on his brain. One of the things you can do is look out for what we call triangulation. That's one person discussing the issue with another person who then discusses it with a third person. Before you know it, you got three people who are all part of this issue, but nothing is being resolved and it's not being taken to management. You also want to go back to kindergarten or to daycare, preschool, and encourage your employees to consider what they say. Is it true? Is it kind? Is it necessary? Those are kind of the rules that we all had when we were playing in the sandbox. Maybe once in a while we need a refresher on those. And you also want to be specific about taboo topics. So what shouldn't be discussed? Well, prior criminal history arguably should not be discussed. Alcohol and drug use should not be discussed. Obviously, personal medical information needs to be kept confidential on an as need to know basis, and sexuality issues as well. So let's move on to our next topic, which is hiring headaches and hassles. Now, how many of you have been there that you post one teensy tiny job application and you get about 250 people for it? And then you hire the person who you think is the best fit, only to go and have dreaded I-9 issues. So in this case, the employer had just hired a new employee, and the employee fills out the I-9s, and she provides a name on the I-9 which doesn't match her documents that she's provided. She says she just hasn't gotten a chance to get to the Social Security office yet. The employer calls us, they say, is this a problem? Can I just take this? Let's talk about I-9s. I have never seen such a supposedly simple document that causes so many problems. So we all know that the employer has first day of employment, you complete section 1, second day within, well, actually section 2 is within the first 3 days. There's also, just to make sure you're aware, a new form that's mandatory. It became mandatory as of January 21st of last year. And there's also the ability to fill out the form electronically. Now, if you fill out the form electronically, it has what's called smart fields. That might be a little bit of an oxymoron when we're talking about I-9s. What those smart fields will do is they will only accept data of a certain type. So in other words, if you're supposed to put letters into a field and you put numbers, it's not going to accept it. Now, I'll tell you, practically speaking, when we talk to employers, many of them are not filling the form out electronically. They're printing it out and filling it out pencil and paper. Well, not pencil, because we know you can't use pencil, but pen and paper. And so if you're having problems with your I-9s, this might be something that you consider doing. So the penalties are high for I-9s, as you saw in the last slide. But here's what the U.S. Citizenship and Immigration Services has to say about the issue that we just talked about, where the employee is finding they're filling out the form with a different name. So they say you can ask the employee the reason for the name change. And if your employee maintains that the name in section 1 is his or her legal name, and you're satisfied that the documents appear to be reasonable, you can take them. But here's the but. You can be penalized from a whole different government agency for your W-2s where the last name does not match what's on file with the Social Security Administration. So while arguably you may be okay on the I-9 perspective, you may not be okay on the IRS perspective. So what do we tell this employer they might want to do? Well, first of all, again, along with documenting, there may be a need for a policy here. So are you going to stress that your employees promptly report name changes? Are you going to consider a practice on name changes? Are you going to say that the person's full legal name needs to be on organization's documents? Are you going to have a more flexible policy? How much does that matter for you? So very often this becomes an issue when a woman takes someone else's name after they form some sort of a marriage or a union with them, and they want to still use their maiden name professionally. So how much does that matter to you when the individual is doing their daily business? For this particular case, the other thing that you might want to consider is requesting that the individual use their time with you to go to the Social Security office, request a new Social Security card, and then get the receipt that they have requested the card and put that with the I-9s and document all of that. That's a way to show that you did your due diligence. So that's something that you might want to consider here. While we're talking about I-9s, here is one of our most boring slides in the deck, but I think it's really valuable. It's a review of what you need to do when you are retaining your I-9s. You can read this, you're going to get a copy of the deck, but what I will say is that you just really need to make sure that whatever system you're using is searchable, that it's secure, and that the only people that really can get into it are the people that need to have a use to get into it for their jobs. Okay, here's our second verification code for this webinar, 8034. All right, and this is our last scenario that we are going to present today, and then we'll open it up to Q&A from all of you. So this is a true story. This particular employer was a seamstress and calls us and says, one of my employees alleges that another employee who happens to be 86 years old threatened her with scissors. Now the employer adds to me that, you know, there's no way this 86-year-old threatened anybody with scissors because she is the nicest employee. She bakes the cookies every week and everybody just loves her. So clearly the employee who's making the allegation has to be just trying to cause trouble. So the employer lets go of the employee making the allegations. So now as an HR practitioner, I'm sure your spidey senses are tingling just hearing this fact pattern. So the employer never investigated and just let the employee go. So as we talk about terminations, and before we really dive deep into this scenario, let's talk Jimmy Fallon. So here are some of the reasons why people have been fired. If we look, the one gentleman was fired on late night hashtags. He writes in, I worked in a frozen food department, thought it'd be cool to smoke weed in the huge walk-in freezer. I was right. But then he found himself on the unemployment line. So one of the main reasons that employers fire, if you look at the stats from Career Builders, is that employees have violated social media policies. Now, of course, we all want to monitor what's said on social media about our companies because we know the potential for things going viral. But you really have to be careful about that. We had a webinar just a couple weeks ago that went over all of that, which is archived. So if you have any interest in hearing what you can and cannot discipline for on social media, go ahead and check out that webinar. Again, email us and we will send it to you. You can see another reason is using the internet for non-work related activity and also for wasting time. Okay, so let's talk about this employer. Go back to it. So some of the thoughts that we shared with this employer is that obviously there are a lot of legal problems that can result from your failure to investigate. It doesn't matter how wonderful the employee is who has the allegation against them and how bad the employee is who's making the allegation, you still have a duty to investigate. Obviously, the employer should have had the facts before taking any disciplinary action. And then since the employer retaliated, the things that you needed to consider at this point are if there was some sort of a whistleblower claim, which we call SEPA, if there was any kind of discrimination. For instance, if the employee says, well, I was fired because I'm younger than the 86-year-old worker and I'm the youngest worker in this particular place of employment. And then also a general claim under OSHA that the workplace was not safe. So obviously this employer should have launched into a workplace investigation before they did anything else. They didn't, but you're not going to make that same mistake. So what we have here is 16 steps if you are going to conduct your own workplace investigation. We always say it's better to get a third person who's objective, who doesn't necessarily know all the personalities and all the baggage in the office. But if you can't do that for some reason, these are the 16 steps. The other thing that I will mention is that you can be creative as to who is going to be part of the workplace investigation if you have a very small office. Now, when I say be creative, I mean, we had an employer call us, they're a small trade association. They were not able to hire somebody to conduct the workplace investigation. So they said, well, there are two of us that are in leadership at the organization. We obviously don't want to bring other employees in because they're not privy to this information, nor should they be. So if we want to bring somebody else impartial in, who do we bring in? So they had a board of directors. They ended up bringing their president in, who was not in the office on a day-to-day basis, to participate in this workplace investigation. So that's some of the things that you can do if you're a smaller organization. But let's get back to what we told this employer to do that fired somebody and should not have. We said, lawyer up. And this is one of my family's favorite movies. And anytime I can interject a My Cousin Vinny slide into a presentation, I think it's a good thing. So I want to leave you with some advice that the judge in My Cousin Vinny gives to Vinny. He says, I advise you, sir, that when you come into my courtroom, you are to know the letter of the law. I react harshly when you don't. And I would say that same advice extends to employers. I advise you before taking any employment action, you know the letter of the law. And if you don't, people are going to react harshly. So that's going to conclude my presentation. Again, Member Action Center is here to help you. We've helped other employers. You can always contact me. There's my direct dial, or you can email us at member411@njbia.org.
Do we have any questions that have come in?
Yes, actually. Thanks, Stephanie. It looks like we have a couple questions already, but I want to stall a little bit of time, give people a chance to type in whatever they were thinking of, because even though you tell people, type them in as they come to you, everybody waits for the end anyway. So while we've been doing this presentation, I've gotten a number of questions asking how to download the PowerPoint slides, so I think that's a good way to stall some time here. You open up your handouts tab on your GoToWebinar panel. It's called hrwebinar.pptx. You can download it, check it out. If you don't want to do that right now, an email is going to be sent to you automatically within the next day or two that'll have the recording and the PowerPoint slides, so you can just wait for those too. With that, just want to remind you, you've got an expert here, so take full advantage of her. The thing that drives me crazy is when we send out our evaluation survey, people reply that they didn't get what they wanted. You know, they were hoping Stefanie would touch on this, or they were hoping Stefanie would touch on that. This is your opportunity to ask the question. So by all means, we have our first question that came in from Carol. If two employees are having an affair, not affecting performance, and not a supervisor-employee situation, do I need to worry about that?
Thank you, Carol. So we have gotten this question before, and obviously you want to try to root out gossip. Gossip is counterproductive to your culture. But in this case, if the two employees are having some sort of a relationship, if it's not a supervisor, it's not a subordinate, if both of them are still performing well, then I think you may just have to let it go and maybe do some sort of sensitivity training for your workplace about not gossiping and things of that nature. But in that case, I don't think it's the same dire situation as the scenario we presented where the employee and the subordinate were having an affair.
Okay, we've got one here from Jennifer who asks, Is there any issue if a female employee who is hiring an outside professional, i.e. an accountant, expresses a preference for a woman?
Yeah, I would think that that could lend itself to a discrimination claim. Yeah, and we've had this question before because we've had, let's say factories or engineering firms or other occupations where, this person is going to walk into an office with, 50-year-old men that have been there for 25 years as a 20-year-old woman, but yeah, age is a protected class, and so you really, really need to make sure that your hiring decisions are not based on age or some other factor that's protected, like heredity, nationality, religion. All of those things are protected.
We have two questions from Stefanie, another Stefanie, and I'm going to loop them together. So she asks, does the new paid sick time law affect public employers? And does the new paid sick time law affect both part-time and full-time employees?
Two great questions, Stefanie, and again, love the name. So public employers are exempt from it to the extent that you are covered under another law, regulation, or rule. So most public employers are covered under another law, regulation, or rule. The other question that you had was part-time, full-time. So yeah, the law does not distinguish with that. What the law says is that the employee earns 1 hour of sick time for every 30 worked. So your part-time employees are going to accrue at a slower rate than your full-time employees, but they will still accrue, so they still will be covered.
All right, Stefanie, I'm going to warn you to keep your paid sick time law hat on because it looks like a lot of the questions coming through are about the new law. So Tiffany asks, if we currently have a paid time off policy with the new paid sick leave law in New Jersey, do we have to offer additional sick time?
That is a great question. So what the law says is, the law says that if you have a policy which is at least as generous as what the law says, that you don't have to offer additional. So that means that you're offering at least 40 hours, that your employees can accrue it at the same rate or maybe even faster as the law says. And that also means that you don't have what we talked about before, those strict call-out policies, those, you have to find your replacement, that kind of thing. So it's a good idea to take your policy and really look at it right now, even if you're providing, say, 60 hours of paid sick time in a year.
Mickey asks if the paid sick time leave was enacted today. I'm going to go with yes, right?
It's going to be enacted today. We expect that it will.
Okie dokie. Hold on, we got a bunch of them here. Suzanne asks, with the scissor case study, how can they determine the woman was really threatened?
Well, again, that would be where an investigation would need to come in. What this employer did was just take one employee's word over the other. And so you wouldn't want to do that. So there'd be an investigation where you would have everybody that could have possibly seen it be called in, interview them, talk about everything that they've seen. Basically, you would want to sit down and take notes and talk about the situation with anybody that could have been a party to it or could have information to share. And again, you'd want to take notes because you'd want to be documenting. Also, you would want to stress that those that are involved would need to keep everything confidential.
Lisa asks if you have any guidance to share on the new pay equity law.
Thanks, Lisa. Yes, we were talking about those fast facts. We have a fast facts, a white paper all about pay equity and what you need to do to justify your merit-based pay decisions. So the new pay equity law is really going to put the burden of proof on you as an employer to show that if you have employees who have similar jobs, that the reason for the difference in pay is not as a result of anything protected, like we talked about, sex, race, that kind of thing. It's not as a result of anything that's protected, it's a result of some other factor. And so yes, we can definitely send you that white paper. You would just need to email us at member411@njbia.org and we'll get that to you.
Roseanne and Lynn basically both have the same question. Roseanne has a second part that I'll get to in a minute, but they both ask, their respective companies just have one generic kind of umbrella for paid time off and don't differentiate between vacation and sick time. Is that okay going forward?
So that's the first part of the question, right? So is it okay going forward? Yeah, the law specifically says that you can just have a general PTO bank, but again, you have to make sure that you're allowing the employees to use the time for the same reasons as the sick leave law provides, that they're accumulating time just as fast as the sick leave law provides, if not faster, that you don't have those strict call-out policies. But yeah, I mean, you can just have that PTO bank. That was an amendment that NJBIA was able to get, recognizing that a lot of employers have switched to a general PTO bank.
So Roseanne would also like to know how the new law affects new employees who haven't had an opportunity to accrue, let's say, 40 hours of paid time off.
So this is Roxanne again, right? Roseanne, you're going to have the option to either front load your time or to let employees accrue it. So a lot of employers will front load the time. They're just going to, for accounting purposes, assume that all of their employees are going to work enough to qualify for the 40 hours. So that's one of the things that you can do. The other thing that you can do is you can require an employee to work for you for 120 days before you award the time. So once that 120 days hits, they can start using the time. And remember, they acquire 1 hour of paid sick leave for every 30 worked.
Donna asks, can we legally have an employee download an app on their personal phone for clocking in and out to be paid, or do we have to provide a company phone for their use?
Oh, that is a good question. I'm not an attorney, so what I'm going to suggest that you do for that question is talk to an attorney who may have dealt with some case law concerning that issue. I think it would be tough if it's somebody's personal phone to require them to do anything with it, but I'm going to suggest that you use one of our legal hotlines that we talked about to try to resolve that issue and talk to an attorney who may have litigated matters like that.
Mary Jane asks, if an employee complains that there is a clique in her department and she is treated differently, if you investigated and it doesn't appear to be true, you check and she says she feels better but is keeping a log of everything that happens in her department between the manager and another employee, should you allow her to write whatever she wants? In other words, leave it alone.
So you're asking if you should leave it alone. There's nothing you can really, if an employee is keeping their own records, which it sounds like she's doing, she's documenting the times where she hasn't been feeling well about what's going on in the office, there's nothing you can do to stop your employees from documenting and trying to protect themselves. I would say that you really need to keep a very close handle on this issue in particular. Again, not an attorney, but it's one thing if people just aren't clicking versus another thing if you're finding that someone is discriminated against because of their race, their ethnicity, that kind of thing. I mean, not everybody's always going to be invited to lunch. That does not necessarily lend itself to a discrimination claim, but I would definitely keep your finger on the pulse there.
Phyllis would like to know, we have per diem employees less than 20 hours that get $1 more per hour but no other benefits, including sick time. Do we need to allow them to accrue sick time?
Phyllis, you can email us and we will send you the exact language on the per diem, but there is a carve out for per diem. It may just be healthcare workers, but we can send you that exact language.
Tara would like to know, how long do employers have to comply with the new changes in the new paid sick leave law?
That's a great question. So we expect that the law will be enacted today, and then it's what's called the delayed effective date of 180 days. So that's going to put us in the fall. And when we send out information later today to our full membership, we will give you that exact date, but it's probably going to be around sometime in October that you're going to have to comply.
Lisa asks regarding pay equity. Do you know how this is different than the current NLRA protections, update policies, and other employment documents to remove restrictions on discussing wages?
Yeah, so this is much more specific than any federal law, and it also has language within the statute, as we talked about, to specifically say what the employees can and cannot talk about. There's also factors that are specifically named in the law that your decisions would have to be based on, which federal law does not have that level of specificity. So that would be like their education, their training, that kind of thing. And again, we have a white paper that outlines all this. We also have a seminar coming up all about pay equity and paid sick leave on June 5th. And I believe that there are still a couple spots available if you want to register for that.
Amy asks, if an employee has a pattern of calling out or scheduling a sick day attached to a holiday weekend or on a Monday or Friday, what are an employer's rights to act for documentation?
That may be hard under the paid sick leave, because right now you could ask for documentation, but remember, under paid sick leave, it's going to have to be 3 consecutive absences. And so, you obviously want to monitor the situation. I don't know if you have spoken with the employee to ask if there is some sort of a reason why this keeps happening. I mean, is it a case where the employee, giving the employee the benefit of the doubt, gets chronic migraines and sees her family on the weekends and the family aggravates the migraines? In that case, there may have to be some kind of an accommodation. Without knowing more, and you're welcome to call us and we can talk through the situation, it's hard for us to answer that question right now. But keep in mind that it is going to be hard to ask for doctor's notes unless it's 3 consecutive absences. Now, the thing that you can do is you can really monitor the performance. So if the person's being out of the office is affecting their ability to do their job, you can document those specific instances, right? She's out on a Monday and that means she's not there to open up the office or to cover a meeting. So I would really be keeping an eye on her job description, what she should be doing, her goals, and are the absences affecting her ability to get her job done?
Elizabeth asked a question and then gave us a few additional pieces of information on the employee, but we'll just keep this pretty general. So in terms of the equal pay law, say you have a new hire who is asking for the same pay rate as the predecessor. Is that required regardless of what maybe their college education or previous experience might be?
So again, this is all general information. We're not attorneys, but so basically the new hire comes in and says, I knew the predecessor, you're paying the predecessor $50,000, and so I am asking you for $50,000. So that's the way I'm going to interpret that question. Again, there are other factors that you can put into your compensation system so that you can have a pay differential, but they have to be justified. So it would have to be something like education, like experience, things of that nature.
Trish asks, do we have to give notification to our employees of the new paid sick leave law?
Yes, Trish, you are going to have to. What is going to happen is that the New Jersey Department of Labor and Workforce Development is going to issue a poster. And once that poster is issued, you are going to have to give notice to them. So it's within 30 days after the poster is issued, you're going to have to give notice to them. But people read the news, so I'm sure that you are going to get employees that are asking questions about it ahead of time. And again, we have that white paper to try to help you navigate those questions.
So I've been skipping a lot of duplicate questions here, but this one is similar enough, but just a little different. Susan says, we offer 2 weeks vacation per year for non-exempt employees. Would this count towards the paid sick leave time?
Susan, again, I think you have to really look at your policy to make sure that you are allowing the vacation to be used for the same reasons and with the same notification as paid sick leave. So I know the big difference between a lot of vacation policies and sick leave policies are that vacation, I have to require you to, I can require you to give me advance notice, right? I can say, if you're taking a day of vacation, you have to give me 7 days notice. With paid sick leave, you can't require that advance notice unless the employee's need is foreseeable. So I think you may be able to go and have that vacation time kind of create one basic PTO bank, but you really have to be careful that the uses are the same and that your discipline policies are the same as well.
Yeah, a lot of questions about PTO banks, but here's another one that's just a little different. So our company has a general PTO policy, but our part-time employees do not get paid for PTO. Do we have to allow them to accrue hours for payment under the new paid sick leave?
So your part-time employees are covered. So if right now you're not providing them with any paid time off, then you're probably going to have to change that policy.
Another question from Roseanne. With regard to the new paid sick leave law, does this law apply to all companies no matter the size or number of employees?
The quick answer to that is yes. There is no small business exemption for it. You may have seen that there were some municipalities that enacted their own paid sick leave that had a small business exemption. There is no small business exemption here with paid sick leave. The other thing I should add is that this state law will supersede or erase all of the local ordinances. There's what's called strong preemption.
Here's one from Shirley. Regarding the new sick leave law, when calling out before or after a holiday, if you have a policy in place that reads an employee will not be paid for the holiday if they call out right before or after, although you have to pay the employee for the day they called out, do you have to pay them for the paid holiday?
Again, not an attorney, but generally speaking, nothing requires you to pay an employee for a holiday. So that's generous on the part of you to pay the employee for the policy, but I don't think that anything would prevent you from not paying them for the policy. But be careful, because paid sick leave has broad anti-retaliation provisions. So you really need to review those provisions, probably with an attorney, to just make sure that by not paying the employee the holiday, that's not seen as some sort of retaliation for them exercising their rights under the law.
Melissa asks, if someone takes a sick day every Monday, can we address it as a performance issue or a pattern if they have used up all of their paid sick time? How do we prevent abuse if there is a pattern but not consecutive days?
So that's a great question. Again, I think that you need to really tie the sick leave. Well, let me back up. I think that you really need to tie the performance to is there some reason why they're not getting their job done? Again, like we talked about before, make sure that the employee is still getting their job done. And if they're not getting their job done, document those instances. So it's not that the employee took sick leave, it's that the employee is not getting their job done. Now, once they exceed those 40 hours, that's it. They don't have any more time to take. And then in that case, you can start documenting the absences, just as you would now.
Donna asks, does the paid sick leave apply to temporary employees in the staffing industry?
That's a good question. So the temp agency is going to have to take care of their paid sick leave. It is not going to be you as the employer who is using them.
Karen asks, will the new paid sick leave law apply to union employees who have a collective bargaining agreement that covers paid time off? Does the CBA supersede the new sick time law?
Okay, so the paid sick leave is not going to apply until the collective bargaining agreement expires. But if a collective bargaining agreement then later gets put into place, it's got to be at least as generous as paid sick leave.
We've hit the 12 o'clock hour. There's still questions coming through. If you want, we'll keep it rolling. So if you have to sign off, go to lunch, by all means, I understand that. Otherwise, the questions are kind of slowing down, so I feel like it's only going to be a couple more minutes anyway. But we don't want you to miss out on any good information, and we're getting a lot here. So our next question is from Elizabeth, who asks, with the new sick time PTO law, is it every 30 hours worked for 1 hour of sick time PTO? So if someone works 70 hours in 1 week, do they gain 2 hours?
So it's every 1 hour for every 30 worked. So you're going to have to keep track of exactly how much they work, and then they're going to hit, when they hit 60, they'll get 2 hours, but keep track of it, right? Because it's cumulative.
Susan would like to know, does a part-time employee accrue prorated portion of the whole 40 hours?
Okay. So it's 1 hour of sick time for every 30 hours worked. So you're just going to keep track of their hours. I'm not sure I understand that question, but Susan, you're welcome to contact us. But it's 1 hour for every 30 worked. So if the employee only works 20 hours a week, they won't have sick leave for that week until they hit 10 hours their next week.
Tony asks, what if I never completed an I-9 for one of my employees?
So one of the things that you would have to do right away is to contact the employee, explain that the I-9 was not done, and provide a time frame for them to go and to provide you with the documentation. But yeah, as soon as you can, complete that I-9.
Neil asked a question kind of following up on what you were just talking about. So he says 1 hour for every worked, not paid, correct?
Yeah. I think, Neil, you're talking about if you just pay somebody because like holiday pay or something. So yeah, so it's 1 hour for every 30 worked, not just paid.
Valerie says, if we have salaried employees and hourly, if the salaried only gets 40 hours regardless of the actual amount worked, how do you count 30 hours?
So in your situation, it may be better just to front load and to assume that everybody's going to hit that time, because I think otherwise it's going to be difficult for you to do that accounting.
Roseanne asks, with regard to pay equity, do you have any advice for getting employees to not talk about and share salary information with each other?
Oh, wow. Is anybody from Division on Civil Rights listening, or the EEOC? I mean, I think it really speaks to your culture. So you need to have a culture that is that's open, where people feel like they can come to the head of your organization and talk about any concerns. But I mean, you certainly can't discourage employees from discussing their compensation or any of their terms of their working conditions. You can get into hot water. But if you have a culture where there's an open door policy from managers, and where people feel comfortable going to management about their concerns as opposed to going to each other, I think that goes a long way.
Barbara asks, do we now have to keep track of hours worked by exempt employees, outside salespeople who work beyond the traditional work hours?
You're going to have to keep track of every employee hours worked if you're not front loading. So that means if you're not just assuming that everybody's going to hit 40 hours, hit that, accrue, work enough time to accrue 40 hours. Yes, you will have to keep track of hours worked.
Catherine asks, I'm going to rephrase this a little bit. She's asking if there's a requirement on how long you have to keep on file somebody's I-9.
So I think it is 3 years from the last date of when they were working for you, but I will look that up for you so you can email me.
Valerie asks, when an employee approaches HR and asks for proof of another employee's pay or what they believe is a pay difference, what do you do?
So there's nothing in the law that says that you have to comment on another employee's pay. So you do not have to provide information. So in other words, if I feel that Vinny is earning more than me and I demand to see his pay, you don't have to talk about that. You don't have to provide that.
All right, then I have a question. Then how does that work? So say Kim, one of our coworkers, comes to HR and says, like, I believe Vinny is getting more than me. There's now a law that says if we're doing the same job, we have to be making the same money, right? So how do you go from there?
Well, again, there's a law that says if you're doing the same job, you have to be making the same money, but there's nothing in the law that says I need to tell Kim exactly what you're making, or Kim says, well, you know, he's getting paid $60,000, I'm only getting paid $40,000. I don't have to comment, Kim, you're right, or Kim, you're wrong. But the other thing I can say is that all of our employees are evaluated, you know, based on their training, their expertise. Kim and Vinny may have had very different skill sets coming into the organization. Vinny may have had a lot more experience on a certain project than Kim does. And so all of that can be factored into your decisions.
Karen asks, do you accrue the paid sick time within a year, or is it constantly rolling over? In other words, is it limited to 40 hours in a calendar year, or once the 40 hours are used, do they start accruing again right away?
So that's a good question. So you can create your benefit year. So your benefit year can be a calendar year, it can be a fiscal year, and then the employee gets a maximum of 40 hours that can carry over. And then, you know, you would just need to keep track of it. So it's possible that the employee gets 40 hours at the start of your calendar year and then has 5 hours that carry over from the previous year.
Barbara has a question that she stated kind of vague, and I'm going to assume we're talking about paid time off. Wait, she just... Okay, so can you front load the time off, the 40 hours for exempt, and not do it for non-exempt employees?
That might be a question for our legal hotline to see how they've dealt with that in other states. Because remember, other states have paid sick leave, and we're pretty New Jersey specific here. So I'm going to give the number for our HR legal hotline, which is 844-424-8197. Now I'll give it again, 844-424-8197. I would ask them how that's been done in other states, because New Jersey is like the 10th state to have paid sick leave. I'd be curious how employers in other states have dealt with that. The other thing is when you use the legal hotline, you do have to have your member ID number, which we can certainly provide you.
So Valerie has a question that gets at what I was trying to ask before, which is then how does pay equity get proved? Like, she asks, will employers be audited at an increased rate? Will we eventually be asked to provide our rates and demographic info at a more detailed level than the current EEO?
So the way it would get proven is if somebody brings a lawsuit against you. And so there's not going to be anybody per se, you know, from the Department of Labor knocking on your door, auditing your records. There is going to be increased reporting for those with public contracts. And so you're going to have to provide more information if you have some sort of a public contract. But this would be in the event of a lawsuit. There's a presumption that the employer has not paid based on factors other than a protected class. And so that's what you'd have to defend against.
Lynn asks, are employers required to carry over unused sick time from one benefit year to the next, which is very similar to another question we had. So I'm going to also kind of add into this another question from Peter. You mentioned paid sick leave. Do I have to pay my employees for unused time when they leave the company?
Okay, so the first question, the employee would be able to carry over 40 hours in a benefit year. The second question, and remind me of that again, that was, do I have to pay them? Yeah, no, you do not have to pay them when they leave a company.
Roseanne is asking a question that I think we covered. Exempt employees work 37.5 hours per week. So is the new law a strict 40 hours or the equivalent of 5 days of regular work week?
It says 40 hours. That's the exact language, is 40 hours. So if you're following the letter of the law, it's 40 hours.
Well, believe it or not, that was our last question. So that looks like a good a time as any to bring this to a close. If you do have extra questions, you can always contact our Member Action Center. Stefanie, how do we get a hold of the Member Action Center?
It's 1-800-499-4419, extension 3, or member411@njbia.org. And you also all have my direct dial and my email. You're welcome to email us directly.
Thank you very much. All right, so when you close out of your webinar today, you're going to get a survey that we hope you'll fill out so we can best understand how to provide you important information in a webinar format. Don't forget, you're all also going to be automatically emailed today's recording so you can review it as many times as you want, especially for those people who asked a lot of duplicate questions. Go back, re-listen to the Q&A. I promise you, if you asked a question and we didn't get to it, it's because it was in, Stefanie had already answered it. So you'll be able to check all that out as well. Our next webinar, NJBIA Live from the State Capitol, will take place Wednesday, May 9th, and will feature an update on healthcare and health insurance. So by all means, feel free to register for that one right on our website at njbia.org. So until next time, for Stefanie Riehl, this is Vinny Civitolo thanking you for being with us this morning and wishing you a great day.